Ladies and gentlemen, boys and girls, hello, namaskar, and welcome to Law Charcha. Today, we have with us a guest who is an expert in medical science as well as law. In fact, the nature of discussion we are going to have is one amongst other reasons for inviting him. An orthopedic surgeon also holding a degree in law as well as master's degree in law, I must say, many other diplomas and certifications in field of law and medicine, and also pursuing an interdisciplinary PhD. He has assisted courts on medical issues as an expert. His distinguishing experience is his service in mass casualty management at ground level in the 1993 bomb blast or the 1998 blast in North Ireland and the 2001 World Trade Center attack in New York. In a nutshell, I would say he is vastly experienced doctor. He is he has worked with established institutions like the KEM Hospital in Mumbai and RN Cooper Hospital, also in Mumbai. I welcome Dr. Satishchandra Kale. Welcome, Doctor.
Rishikesh, thanks for inviting me to this program to share my thoughts and a few pointers on law and medicine in relation to the topic today. So, thank you for inviting me and thank you for your kind words.
So, first and foremost, are the laws on termination of pregnancy in India well framed? And I have to ask a sub question to it. You can answer it in two parts as well. One, are the laws well framed? And secondly, are they in keeping with the demographic situation or demographic condition of the country? Or do you think demography of a country should not matter at all in devising such laws or legislating such laws?
Thank you for this question. Very important for a country like India, which is the most populous nation on the planet. The laws in relation to abortion, or as we rightly say, medical termination of pregnancy, are sketchy and they're open to misinterpretation. They are purposeful or otherwise by patients, their families, and also by healthcare establishments. But my strong feeling is that the demographics cannot matter beyond the purview of law and beyond the purview of medicine. If demographics mattered, then forcible abortions or forcible sterilization would be the order of the day, as we had seen sometime in the past. Now, that was quite an infamous attempt by the government to curb population, the thoughts being rightly so, but executed in a completely wrong fashion. So that was illegal and it was condemned and it was eventually stopped. Secondly, there are, for a country like India, which has got many moral and religious issues, along with just legal issues which exist in the West, we have got additional layer of morals and religion and our culture, which also needs to be kept in mind because more and more Western countries are adopting to our line of thinking, which I will allude to later on in the interview. For example, Garbha Sanskar, as we call it,
Yeah.
or जे आपण प्रक्रिया करतो on the unborn fetus,
Yes.
that is taking up in a big way even in the West. So that means that the Indian philosophy at some point is percolating to the West, and we don't have to ape the West blindly. We have to adapt the laws as relevant to our culture, our religion, our local issues. But abortions cannot be ever considered a demographic tool in reducing the population. That's my main take on the issue.
Well, that is a very pertinent aspect also, and very well put by you, Doctor. In this backdrop, recently Supreme Court had to face a different challenge, and the challenge also had to be dealt with differently, where an order of the Supreme Court had to be recalled. On first instance, bench of two lady judges gave a verdict in favor of terminating the pregnancy. Then, based on a doctor's email seeking clarification, the matter had to be placed before the same bench. After that, there was a split verdict given by two lady judges, where Honorable Justice Kohli observed that her judicial conscience prevented her from allowing the prayer in view of the email from doctors. On the other hand, Honorable Justice Nagaratna gave more consideration to the interest of the mother, her socio-economic and mental state, etc. So, what is your take on this, considering the email from the doctors?
Uh, First and foremost, it is a very landmark judgment. I think it's a judgment which will lay the law for the high courts and the lower courts to follow. Because there were instances where some courts were allowing great latitude in allowing abortions beyond the stipulated date. I am not against every procedure. Please correct me. Please understand me. I'm not against every procedure of abortion. Some of them are required, some of them are genuine, some of them are contraceptive failures. But what I'm trying to say is that beyond a certain point where there is medical evidence that it should not be done, and what is inbuilt into the law under the MTP Act, we should not be contravening. Now, a few points which will come up, which have been mentioned, I will pick up one strong thread. The Honorable Justice Kohli gave a dissenting judgment because she feels that the feticide will cause the doctors to stop the heartbeat before the termination. Now
Hmm.
that's a very important concept. Now, what is the difference? The heartbeat does not come at 26 or 27 weeks. The heartbeat actually starts at 6 to 8 weeks. So the stopping of the heartbeat is not the central theme here. What the doctors meant to convey by this sentence, stopping the heartbeat, is that the fetus was likely to be viable despite the medical termination procedure. And the child may be born alive and it might be premature and then subject to other complications because it is living outside the womb of the mother. So basically, a few points which got highlighted from this judgment. It's a very interesting judgment. I urge all the interested parties to read into this, especially people who deal with that area of litigation. It shows that the honorable courts cannot work in isolation and or the medical community. They have to work in tandem, and the laws have to be interpreted alongside each other favorably, not against each other. So the medical evidence certainly overrides the legal opinions in the first instance. Is my take on the matter. Then it also on the other side shows a pitfall where a court can go beyond its jurisdiction to direct an abortion which is outside of the MTP Act, which is beyond the legal purview. Now, in doing so, it puts the doctors at great strain because they have a conscience, and beyond a certain stage of what is allowed under the law, it heavily weighs on their conscience. And known or unknown, it also heavily weighs on the conscience of the people who are undergoing the abortion, including the woman and her partner, husband, boyfriend, whatever it may be.
Hmm.
Thirdly, this judgment has also shown up that the medical professionals were not completely happy with this judgment, and that is why the doctor wrote an email to the Assistant Solicitor General, who took up the matter speedily before Justice Kohli, and it was referred on to the Chief Justice, who constituted the bench, etc. So I think the time has come for the doctors to speak up for what is right medically in relation to the law. I'm not trying to go beyond the purview of law here. Number four, it is quite easy to portray a person who is beyond the legal date of abortion as a victim. And then all sorts of flimsy arguments start coming up. Now, rightly or wrongly, I'm not judging the background of this particular person, but there have been a spate of cases where the same argument holds true that socioeconomically deprived, depression, additional burden on the family, the husband has many hands to feed. But that is not something which is new. It was already existing before. She already has two children to begin with, and that we cannot lose sight of. So, the loss of job, divorce, proceedings, separations cannot be a factor in serious judgments. Beyond the MTP Act is all I'm trying to say. Then judges can only implement the law which have been made by legislature. Judges usually administer law, they do not make laws. And this is one of the fine examples where the Chief Justice has drawn a clear distinction that he is not the one who interfere with what has been legally prescribed under the MTP Act and where the candidate is not satisfying the eligibility criteria. So he has actually reinforced that idea that the laws have been made by legislature with great thinking, great input from the medical professionals, legal professionals. So it has not come across, it has not come around in a day. It has taken the time for this act to come through. So having said that, the judicial officers at the lower courts especially, where such judgments have been given in the past, particularly various high courts. I don't want to point out any high courts in particular because there might be mitigating circumstances. But on the whole, this has laid the law for what the lower court should be doing as well, so that there is a uniformity in enforcement of the MTP Act.
Yes, yes. So, having had a glimpse of the medical opinion in the email of the doctor, it is also important to check the medical board's conclusion in the report. So, can you put these conclusions in more simple words for our viewers?
The actual medical report is anonymized, as you already know, because the litigant in question or the petitioner has been anonymized, and rightly so, because
Yes,
the identity of the
that's
woman is not in, yeah, is not a matter of discussion here.
we
It
are, we
could
are
be
trying
anybody.
to just understand, like, for in simple words, what was the
Yes,
conclusion of that report? We are not to do with the identity at all. Just it could be any
right.
patient or any
It could be any patient.
medical
That's correct.
case.
So here I will point out, one or two pertinent points here. Number one, the board on two separate occasions have ruled that the lady is capable of having a normal delivery and is capable of delivering a normal child, which she can put up for adoption later, because the petitioner was categorical that even if the child is born alive, I do not wish to keep the child. Now, that is a personal matter again between the
Okay.
parents and whether they want to give up for adoption and the reasons thereafter. So that will not uh, concern us. The second point, which I re-emphasized in the first instance, is that the doctor said that we will terminate the pregnancy or will attempt termination, but you will have to give us a direction to stop the heartbeat if the child is born alive. And that is a very, very, very important thread which runs through this. Because what happens after 24 weeks? There is a reason why the MTP Act has said 24 weeks uh, as a cutoff period. Because a child is likely to be born alive, and there are instances where premature children survive and they progress well into childhood, adulthood, etc. Now, thirdly, why such abortions are discouraged? So this medical reports is in tandem with that. People are thinking that it's my body, it's my fetus. I have a right to procreate or destroy. No, that is not so. What is the central thread in the MTP Act? The life of the mother. So substantial risk to the life of the mother, physical or mental. So, what are the complications which could occur in a late abortion? Let me just reiterate. And when I'm saying abortion, I mean unindicated abortions, where other factors are being petitioned as a cause for getting this abortion done. Okay. So, heavy bleeding, and the patient can, or the woman in question can lose her life. Very few people are aware of this. There can be severe and fulminant infection because the baby is large. Normal delivery is difficult. There sometimes can be uterine tears during. So that termination in itself is causing, is likely to create a host of complications. Then cervical incompetency, where there is a difficulty in closing the private parts, the mouth of the private part, as we call the cervix in a woman. There can be bladder incontinence. There can be a condition called DIC, called disseminated intravascular coagulation, because this is a trauma. Termination is a traumatic procedure after a certain period of weeks, because the child is large, the weight is heavier, and there is more difficulty in passing. And lastly, and not very unlikely, the baby, the fetus, sorry, I will not say the baby, the fetus can be born alive, can be in prolonged respiratory and intensive care, and can suffer from mental issues because of oxygenation being prolonged on the ventilator, infections in the ICU, etc., etc. So when people go for abortions in a late period, they say that we are getting rid of unwanted pregnancy. They do not realize that there is a great risk to the life of the mother the later the pregnancy is terminated. And hence the medical laws are clear, of course supported by the MTP Act, as to why we should not be terminating. So the board has rightly ruled that she does not have a fetal abnormality. I will be very specific with 3 or 4 points as picked up by our Honorable Supreme Court as to why they did not allow. Because they found that there is no fetal malformation, there is no abnormality in the fetus. That's first and foremost. Right? Secondly, the woman was suffering postpartum depression, which was being treated effectively, and the drugs which were used were unlikely to create any damage to the woman or the ongoing fetus. So these are the 2 or 3 things which the Supreme Court considered, and rightly so, and gave this verdict. So the medical board on this front has stood up for itself, has spoken out, or one of the doctors from the medical board. And I think in this instance, it seems to have clarified the approach of the Supreme Court as to the uh, what the path should be in a litigant who comes in for such late abortions.
I suppose, and also the path is kind of legislated also when it is with respect to termination of pregnancy. We would like to know the criteria of termination of pregnancy from you. But before that, since we were on that particular petition in the Supreme Court, and the petitioner had said that she did not know that she was pregnant until after 20 weeks of the pregnancy. The pregnancy had elapsed since the 20 weeks because she had lactational amenorrhea. I don't know whether I have pronounced it correctly. Can such scenario happen where the woman doesn't know that she is pregnant even after 20 weeks? Is it like how much possible is it that even after
I
20
will,
weeks she doesn't know?
right. It's a very important question because that is a common ground taken by the petitioners that I wasn't aware of my pregnancy. So here I will like to divide it into 2 parts, medical and social. Okay. So medically, lactational amenorrhea, which means that absence of menstruation,
Hmm.
is a possibility. No question about that. It is a possibility. In medicine, all permutations and combinations are possible. Some of them are rarer than usual, but they're possible. But at the same time, there is also lactational anovulation, which means that no ovum is produced during lactation. So both are equally true. So either it's true or false, or there might be a permutation combination. Very difficult to say whether lactational amenorrhea caused this ignorance about her pregnancy. Very difficult for me to comment on. But suffice to say that it
Of
is not
course, doctor, since like we are not on, we are considering this case only from the educational perspective. So we
agreed.
are only examining the likelihood of such scenarios.
I
So we
agree.
are not at all concerned with that particular litigation or that litigant as such. So
No, but
you can
when
be
this is
you can freely explain the different scenarios that can
right,
happen or how likely such scenario is to happen. We are just
it is.
educating ourselves.
See, as a fact, is lactational amenorrhea common? It could be, yes. But it has to be read in conjunction with what the petitioner has put forward before the court. We can only comment by what the petitioner has disclosed to the court.
Mhm.
Now, this petitioner is 27 years old.
Mhm.
She was 27 weeks pregnant when the Supreme Court has given this direction to continue the pregnancy. To be precise, 26 weeks and 5 days, which is approximately 27 weeks. Okay.
Yes.
She already has 2 children living from her existing marriage. So a person who is already had 2 children, it's unlikely that she will miss the signs of pregnancy. The reason, simple reason, because she has been through the experience twice before. Okay, so it's a very uncommon
That is true.
situation where where she claims that she
See,
did not know.
that is
Secondly,
reported also that this was her
now
third child.
correct. The another thing is very interesting. I thought because I applied my mind to the judgment. She claims that she is suffering from severe postpartum depression. Now, cases of severe postpartum depression, Rishikesh, you might not have seen any, but they are quite serious. I mean,
Okay.
sometimes there is rejection of the child. It can be as extreme as that. And if it is severe enough for her to drop her pregnancy, But at the same time, the fact remains that she did become pregnant for the third time. There is no mention whether they were indulging, whether they were using any barrier contraception. So you see, in isolation, is lactational amenorrhea possible? Yes, it is possible. But when now it is combined with the other factors, social factors, which the woman claims that she has had two children before. She has been to two pregnancies and she has delivered normal children. So postpartum depression is not going hand in hand with the other scenarios, is what I'm trying to say. So in isolation, it might be a valid reason, but when it is studied in combination with various factors, this seems implausible now to me. But I will be taking a step back here. Medically, anything is possible. I understand that, and lactational amenorrhea is not uncommon. But at the same time, in combination with other factors, I find it difficult to believe at a personal level. I don't want to comment on whatever has been committed into in the judgment.
More on this in the next part with Dr. Kale.